Hare Krishna. Welcome to Tax Guru YouTube channel. This is CA Rohan R. Pingre, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Madras Network. Welcome to the video series What Law Says. And today we are going to discuss two important case law reported to High Court that is also recently in February and in March under GST law. One is related to ITC distribution through ISD, and other is related to non-filing of appeal through electronic portal. So let's dive into it. Let me allow to share my screen. Yes. So today's first case, Reliance Jio Infocom Limited versus Union of India, Madras High Court, and date of order is very recent, 5th March 2026. Let's understand facts of the case. Reliance Jio Infocom Limited, a major telecom company, operated as an input service distributor with a multiple GST registrations across the states. So it received common input services and distributed the corresponding input tax credit pro rata to its branch units based on the turnover. So revenue issued show cause notices alleging that delayed distorted distribution of ITC for financial year 2018-19 to 2023-24. So Reliance Jio, a major So notices claimed violation of Rule 39, Subrule 1, Clause A of the CGST rules, which allegedly mandated distribution in the same month as the underlying input service invoice. So Jio challenged these notices via writ petitions, arguing that the distribution could only occur once ITC legally became available. This is the main cost of the case. So let's understand issue under consideration. Whether an ISD must distribute ITC in the same month as the receipt or issuance of the supplier's invoice under Rule 39 Subrule 1 Clause A, or only after the ITC becomes legally available or approved upon satisfaction of all the conditions under Section 16 subsection 2 of the CGST Act 2017. So validity and interpretation of the same month distribution requirement in Rule 39 Subrule 1 Clause A. Very interesting. So let's see what are the relevant legal provisions. Section 20 of CGST Act 2017 governs the ISD mechanism, that is input service distribution mechanism for distribution of credit of input services on a pro rata basis. Section 16 subsection 2 of the CGST Act 2017 lays down conditions for entitlement to ITC, that is possession of invoice, receipt of the goods or services, tax paid by supplier, and filing of the returns. That is the conditions need to be satisfied or mandatorily complied. Rule 39 Subrule 1 Clause A CGST Rules 2017 procedure for distribution of ITC by ISD, including the phrase input tax credit available for distribution in a month. So let's see what were the contentions of the assessee. Assessee contended that ITC doesn't arise merely on invoice receipt. Distribution obligation triggers only when all the section 16 subsection 2 conditions are met and credit legally accrues. Forcing same month distribution before eligibility, that is legally eligible, would violate what statutory conditions and cause hardship for the large entities. That was contended by the assessee. So what contended by the revenue, that Rule 39 Subrule 1 Clause A mandates the distribution in the same month as the invoice to prevent what leakage and ensure timely credit flow. Any delay contravenes the rule is what contended by the revenue. So let's see what High Court observed and held. The expression input tax credit cannot be equated with mere input tax or the invoice value. That is the first observation by the High Court. That expression input tax credit cannot be equated with mere input tax or the invoice value. ITC becomes available for distribution only and only after it legally accrues upon fulfillment of section 16 subsection 2 conditions and not merely on the invoice issuance or the receipt. That is not only one condition need to be satisfied. There are 4 to 5 conditions need to be satisfied. Then only the ITC becomes legally eligible to distribute. So revenue strict interpretation is that based solely on invoice one was held incorrect. However, the court upheld the validity of Rule 39 sub Rule 1 Clause A same month requirement, interpreting it harmoniously. Distribution must occur in the month when the ISD actually becomes entitled, that is legally eligible to the ITC under section 16 subsection 2. So writ petitions were allowed in part, show cause notices were set aside or required to be re-examined in light of this interpretation. So let's see what principles laid down by this case. ITC eligibility and distribution timing are strictly governed by section 16 subsection 2 of conditions. An invoice alone, only one, doesn't create distributable credit. Rule 39 sub rule 1 clause A same month distribution applies to the month in which ITC legally becomes available, not the invoice month. As the obligation must align with what substantive ITC entitlement provisions, harmonious construction of GST provisions is essential to balance what procedural timeliness with the legal accrual of the rights. So, moving further, let's move on to the case 2 for the today's discussion. Harsha Trading Private Limited, Hyderabad versus Additional Commissioner of Central Tax, Andhra Pradesh High Court, and date of order 23rd February 2026. Let's see facts of the case. The petitioner engaged in trading commercial vehicles, parts, accessories, and related services faced a GST assessment order or demand. It filed an appeal after paying the mandatory pre-deposit. Due to technical or portal issues, assessment order allegedly not uploaded properly. The appeal was filed what? Manually. Very important. Due to technical glitches, appeal was filed manually. The appellate authority initially accepted the manual appeal, issued a hearing notice, and heard the matter on merits. Later, it dismissed the appeal solely on the technical ground of non-electronic filing. The very important and very interesting. The petitioner challenged this dismissal via writ petition. Means earlier they accept that manual filing, they issued the hearing notice, they heard the matter, and after that, again they dismissed that appeal because the technical ground that non-electronic filing. So now let's understand issue and recognition. Whether an appellate authority having accepted a manually filed GST appeal, entertained it, issued notices, and heard it on merits, can subsequently reject or dismiss it purely on the technical ground of non-filing through the electronic portal. Very, very interesting. Let's see legal relevant provisions. Section 107 of CGST Act 2017. Procedure for filing appeals, including time limits and pre-deposit. Rule 108 of CGST Rules 2017. Form and manner of filing appeal, generally electronic with scope for manual filing in certain cases. That is the rule involved that particular manual filing. So principles of natural justice, estoppel and waiver in procedural matters. So let's see what contended by the assessee. Once the authority accepted the manual appeal, processed pre-deposit, issued notices, and conducted merits hearing, it could not later on dismiss on a technical filing defect. This caused what prejudiced after prolonged pendency the appeal deserved decision on merits. What revenue contended is that appeal filing must strictly comply with the electronic mode under the rules. Manual filing is not permissible or sustainable, is what contended by the revenue. So let's see what High Court observed. Once the appellate authority accepted the pre-deposit, entertained the manual appeal, issued notices, and heard the matter on merits, it ought not to dismiss it later on the technical ground of mode of filing. So, objection to manual filing should have been raised at the inception, not after long delay. Very clearly, High Court said that objection should have been raised at the inception point, not after the long delay. Such post-hearing technical rejection violates what principles of natural fairness, justice, and causes what grave prejudice. So the dismissal order was quashed and the matter remanded for decision on merits without reference to the filing mode. So the court emphasized independent adjudication and fairness in appellate process. So what principles laid down by this case? Once an appellate authority accepts and proceeds with an appeal, including manual filing, it cannot later reject it on a technical procedural grounds like filing mode, especially after hearing on merits too. So objections to filing defects must be raised promptly at the initial stage, not after substantial proceedings. So GST appellate processes must prioritize substantive justice and merits over the hyper technicalities when no prejudice to the revenue is shown. So authorities are stopped from belated technical rejections after inducing the appellant to participate fully. So that's it for today. Thank you. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. And if you are not yet subscribed to our YouTube channel, then do subscribe for latest updates and video series like this. Hope you are gaining valuable knowledge from all these updates and video series that we are conducting on a Tax YouTube channel. Thank you. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.